So thanks for attending this breakout session. I know it's a little tough after lunch and the lights are a little low, so please feel free to raise your hands and ask questions so that we can keep everybody awake and engaged in what we're talking about. My name is Suzanne Bell. I'm a partner at Wilson Sonsini in the Technology Transactions Group. Right next to me is Aileen Casanave, who is Senior Director and Senior Corporate Counsel of Global Licensing at TIBCO. Next to her is Rahul Matthan, who is a partner with Trilegal in India. And then to his right is John Menton, who is with Arthur Cox Solicitors in Ireland. And so thank you for everybody for coming. I appreciate having the in-house perspective, so Aileen, specifically, thank you. And I also appreciate the folks who traveled across oceans to get here, so thank you very much. So this is a best practices seminar. So we're going to be talking some nuts and bolts here in negotiating cloud computing agreements. I get the question of what is different in a cloud context from on-premises software. There he is.
Hi, my apologies. A little bit more traffic than I expected.
Yeah, it can get that way. Well, we just started, so you're right on time. Mark Radcliffe, partner with DLA Piper, has
Thank you.
just arrived, just in time delivery. So I get the question of moving to a cloud solution from a more customary on-premises solution in two different contexts. One is a vendor who's looking to move to a hosted cloud-based platform rather than offering on-premises software, and two is a customer who's looking to using a cloud-based solution instead of installing on-premises software. So I'm going to go through, kind of as an introduction, a set of the key issues that I see in negotiating those agreements, kind of day in and day out. I'll also note that as a customer, it's important to do some diligence as well in your cloud services vendor. So there'll be a couple of cases in particular where I talk about that. So the disclaimer before I launch into the important issues to negotiate is the fact that for large public cloud services, your ability to negotiate these terms is very limited. So for those services, you're trading cost and convenience for robust reps, service level commitments, et cetera. And so these are the terms I'll go through in an ideal world that you can negotiate, and in many contexts you will find yourself negotiating and needing to negotiate. In other contexts, it may not be worth it given that trade-off between cost and convenience on the one hand and robust representations and warranties and service level commitments on the other. So the first issue is service level commitments. As a customer, you're going to want commitments around uptime, support response times, and bug fixes. As a vendor, you're going to want to limit those commitments and limit remedies to service level credits, caps, termination rights. So that's number one, service levels. Number two, data privacy. We've heard a lot about that at this conference in different contexts, so I won't dwell on it except to comment that few vendors are actually asking to use their customers' data for purposes other than providing or improving their services. Cloud services vendors aren't typically looking to use that information to market to those customers, but cloud services vendors do often see great value in the use and possibly even sale of aggregated non-personally identifiable data. So that is an important term to negotiate if you're the customer in that context. For cloud-based services where the vendor is providing a service that is in turn used to provide a service to end users, it's important to identify whose privacy policy governs in that case. And then again, data privacy becomes very important for cloud-based services who are providing services to users in multiple jurisdictions. And so understanding where your data is stored and by whom and who has access to it for what purpose is all critical. So second issue that's tends to be a very large negotiating point in cloud services contracts is data privacy. The companion to that is data security. Customers are going to want to impose at least a minimum level of security, but the fact is vendors can't be bound by different security policies for different customers for what is it's a single service in a sense. So that's an issue where you're a customer looking to impose specific security requirements. And compliance with data breach notification laws, if there is a security breach, can actually be fairly expensive, especially if it involves paying for credit monitoring for the affected users. So again, the dynamic, vendors want to limit their liability, and customers don't want to limit the vendor liability. It's really as simple as that. So vendors are protecting themselves in a sense by requiring that only encrypted data reside on their services, so they're not on the front lines in a sense for that. Other negotiated solutions where that is not necessarily, sorry about that, possible is sharing some liability depending on the relative fault of the parties, of the vendor and the customer involved. But again, for small customers using large public cloud services, there's not a lot of room to negotiate there. Another issue related to privacy and security is notification of law enforcement requests. And it was very interesting when we heard the magistrate talk at lunch about that, how surprising to him, infrequently he gets pushback from companies who are the subject of search warrants asking for data. And as a customer, what I always ask a vendor for is notification unless that vendor is prohibited by court order from telling me that my data is subject of a search warrant request. You'll often have a vendor who wants to say, I don't have to tell you if the government has requested that I don't tell you, but I try to limit that to only if the government has issued a court order saying that they can't tell me that my data is the subject of a search order. Next is business continuity and disaster recovery. Again, customers want basic reps around business continuity, disaster recovery. Vendors don't want to be bound by differing standards from differing customer policies. The next is, as a customer, your dependence on vendor and third-party technologies. So what customers want is notification and even approval over changes to the service. If as a customer you're dependent on that service, you want to make sure that you have notice and approval over changes. It's the flip side of that is a vendor who's offering a standard service and has to have a single policy. To the extent that the cloud-based service involves technology that's licensed in or services that are added on from multiple customers, which is often what we see. We don't really talk about SaaS anymore, software as a service, because that kind of implies there's one software program that's, instead of being on premise, it's hosted. More often we're talking about cloud-based platforms that are perhaps an aggregation of a number of different technologies. So what happens if the vendor loses rights to that service and the customer is really dependent on it, kind of what happens at that point. So understanding what the third-party dependencies are is important for a customer. Next is termination. The more dependent on a cloud-based service you are, the more important it is to negotiate a wind-down period and transition services and getting your data out. What I find is that vendors often want to limit those rights in the event of a termination for breach, but customers don't want their data held hostage. And what I do try to negotiate when I'm negotiating for a customer is specific performance around data access upon termination. Next issue is acceptable use and use of the services. As a vendor, you want to impose some kind of acceptable use policy, how the service can be used. And rights to suspend the service if those policies are violated. In a regulated environment, all of these issues become much more complicated. So the obvious ones are personal health information or financial information. So in transactions, there's often a clash between a customer that wants to impose industry-specific regulatory requirements on the cloud services vendor, and a vendor that doesn't view themselves as a regulated industry in that particular industry and doesn't want to be bound by the whole realm of regulation for companies in that industry. so often there's a detailed negotiation, and vendors who are not experts in that particular area often have to go get specialized counsel to help them navigate what is a nice to have that the customer is asking for, what's an ask versus what regulatory regime, what of the regulatory regime the vendor really is subject to. IP indemnities is one that we transactional lawyers negotiate day in and day out in a whole variety of contexts. Like a lot of other things in a cloud context, it becomes more complicated, especially as it relates to combination claims, and there have been some new developments that may make that a little bit easier or a little harder to negotiate depending on your perspective, and we'll talk about that too. So before I open it up for a couple of specific tricky issues that we've identified that we'd like to talk about in more detail, I will note that we are really talking about cloud services in a B2B context, but not focusing so much on that transaction agreement that you click through as a consumer using a cloud-based service such as email or storage, although some of those consumer services are implicated to the extent that the vendor of the consumer services is using a third-party cloud storage vendor to host their service. So that is a segue into the first issue that I'd like the panel to address. That is, as a vendor of application services over the cloud, if you yourself use a public cloud vendor to host your service, how do you negotiate customer agreements if it's a B2B service, not just a click-through? How do you negotiate a customer agreement when customers are demanding protections that you actually cannot back up with commitments, on the other hand, from your public cloud vendor? And this is, I think Mark called this the kind of layer caking of services. So examples of things that you may want to, that your customers may ask you for that you're not getting from the public cloud vendor are service levels and security protocols, just to name a few. But really, in a way, the whole list of major issues and cloud agreements that I just went through could be subject to this issue of you're being asked to give what you don't get. So I'm going to ask Aileen to respond to this one first and tell us how she deals with this problem and what her experience has been at TIBCO.
So prior to TIBCO, I was at Sun for 10 years, and cloud, has its early infancy in the last, I would say, at least 10 years. Back then, it was very difficult because obviously we would be negotiating the cloud platform in advance of GAing our product. So we would be an inbound license agreement for the platform at the same time as we're developing our software tool, at the same time as we're putting together all of our requirements, and it's a very fluid activity. We GA the product, and the next thing you know, every customer wants to negotiate something that obviously we count as an inbound agreement. So it made it difficult. But as cloud has become a very normal platform to provide products and services, it's almost like open source. You get what you get. You give what you give. That's all you can do. And so we kind of take that approach. As we're negotiating our terms and conditions, we basically use it as a risk aversion in the negotiation process. We tell the customer, you're getting Amazon. Everybody uses Amazon. This is a positive thing for you to do, to allow us to put our platform on Amazon and for you to trust Amazon because everybody's got it out there. If there's going to be a problem, Amazon's going to see it, because how many users send daily responses into Amazon to say, I've got a problem, I've got a problem, I've got a problem. Everybody hacks Amazon. So do we have to worry about being hacked? Yes, but everybody else does too. So it's kind of that benefit that you use in negotiation and say, it's like open source. Everybody's got it. We're all going to put Apache in. I can indemnify just like you can indemnify. I can ask just like you can ask. We do kind of the same thing with Amazon. We basically say, go to the Amazon website. That's what they tell us to do. Look at their uptime. Look at their availability. That's what they tell us to do. And then at the end of the day, they give us a contract that says absolutely nothing. Commercially reasonable as commercially reasonable efforts to be up. What does that give you? Zero. So then we have to decide, okay, for certain customers, are we going to take a step forward into a different area of risk and maybe provide an SLA that does say 99.7 as opposed to 99.9% uptime. And then for that, we say, okay, and if it's not, well, first of all, we caveat it, right? So any downtime that's on a brownout or some kind of a core drop is not ours, it's not Amazon's responsibility, not included. So there's certain things that we automatically look at with respect to downtime that we put into the equation. And if you go to Amazon site, they actually have the definition of those instances or occurrences where no one covers anything. And they're beyond just the definition of force majeure. They are specific instances where, because again, when you look at force majeure, if you have both your existing site, your hosted site, and your disaster recovery in the same risk place, they're both on an earthquake fault. Is it foreseeable that you're both going to have, that's not force majeure anymore. So going back to what you can give and what you can't give, we do try to at least negotiate some terms and conditions that provide customer additional support. We may give them credit for the event that there's a downtime where there's a question as to whether or not it's our product interfacing with the Amazon platform, and we've determined that it's not our fault, but we can't get Amazon to prove that it's theirs, which is also a situation, right? That whole interface between the two, and Amazon is saying, I'm not admitting anything until I verify it, and even then, I'm not going to admit it, because what are they going to do? Worldwide, big problem, right? So there's often times where we'll come up with a solution. Another solution may be, and we haven't obviously had to deal with this yet, but I could see situations in the future where your indemnity provision says repair, replace, or return or refund. The replace may be to take yourself off of an Amazon and put yourself on your own hosted environment. And that's something that people are starting to really look at with respect to advising the customer, okay, we are using this commercial site, why? Because it's cheaper. And the updates are there. And we don't have to worry about making sure that those thousands of hits that you get every day, that we have to track them on our system. We have at least 3 products where it is hosted on our environment. We have a rewards program with several of the big retailers where we provide the loyalty rewards service, and that's on our website. We decided to use our own platform because in those particular instances, the community is not really hacking loyalty sites. They're hacking other types of sites that provide other types of services for a greater risk to the community, or to basically penetrate certain types of data. We're not getting those kind of hacks yet, but one of the things that we could do with our own site, and we have in our last negotiation, is to say to the customer, repair, replace, including taking ourselves to a commercial site and the costs associated with that transfer. That's a big win. But again, when you negotiate something like that, you've got to figure out and know in advance and have finance and rev rec look at what is the cost of transferring yourself from an Amazon, a Rackspace, a marketplace to your own site, and then in the reverse. Let me go back to my notes real quick. The other thing is, another example, just real quickly, is penetration testing. That is like the latest, greatest, newest. Everybody wants it. Everybody's looking at it. Data security, data privacy issues. And in that situation, penetration testing, for those of you who don't know what it is you send a signal to a port, and for instance, it has listeners, and it may say the response to that port is page 404 not available. We all see that. That's an Apache response. That means Apache is in there. Now you've determined what is it's basically reverse engineering. You've basically sent a message to a port that basically tells you it contains something that you wouldn't otherwise known because it's a hosted environment and you can't drill down. So penetration testing is sending signals to the hosted environment, trying to determine what's in that hosted environment, to then start sending attacks to actually break it down and do either a positive or a negative thing to it, either destroy it or show that it has certain weaknesses. Obviously, we say no benchmarking, right? How many people have a no benchmarking clause in most of their contracts? Almost everybody. We also say no penetration testing. Amazon has their own penetration testing, but they do it to a certain level. They don't do it to certain operating systems. So their penetration testing is not as good as what we would want to do. And do we have the right to do it? Of course not. We negotiated this contract way back when, and they're not going to change it. So now the types of remedies, professional services. You go pay to say, can we do penetration testing of this product with this operating environment, with this particular software stack, and we, TIBCO, go pay for that, and then now we can advertise it as it was subjected to specific penetration testing. It met the certain requirements on this date as this type of testing. So we don't talk about warranty. We can give a warranty. We can give a representation as to that particular date. Obviously not a covenant going forward, because we'd have to continue the testing unless, again, the professional services gave you that additional obligation to continue the penetration testing going forward. So there's always ways to go through this. I consider this just like open source. When we first started talking open source and all the different things that we had to do associated with using open source, initially just trying to figure it all out, and then now pretty much everybody kind of understands it. Cloud is going to be that same way. Everybody's got to figure out, okay, you're putting something on top of something else. You shouldn't be responsible for the something else, but you're an end-to-end service provider, so they're going to want you to be responsible for the whole thing. And either you flow through theirs and say, you know what, I'm responsible for this, and here you can take whatever they give you, or you're responsible for 100% of it, and you got to figure out, what can I do to get past that without showing up in court with no one standing behind me?
Thank you. Very helpful and very, very practical, I think. I appreciate the approach. I'm going to see if Mark has anything to add to that.
Yeah, I think I agree with what was said. I think it's really important, particularly if you're using a brand name like Amazon, to be able to point to them. Unfortunately, in negotiations, sometimes you don't have that liberty. And I was in one negotiation where at the tail end of the negotiations, a large company in the Valley basically said, well, here are the additional service levels we want. And we said, well, wait a minute, we told you from the beginning, we're basically buying, we bought these cloud services from a reseller. The reseller certainly can't change the services, and we don't have the leverage to change the services with the cloud service vendor. And their response was, well, we always get these terms. And we said, well, yes, you're XYZ Corporation, I'm sure you can, but we're not. And nonetheless, at the end of the day, we did take on some risk that was not covered. I think one other point that is important to think about is if you're building a service on top of a cloud service vendor, and this particular example is a good one, is you need to make sure you pass through those limitations. So, for example, in this particular case, we had the cloud service vendor, then we had the reseller, then we had my client. My client built a platform on which the customer was then going to build its own applications, which would then enable customers build their own applications. So as you think of it as a layer cake, that's 5 layers, and my client is a layer 3. And so we needed to not only pass through limitation of liability, compliance with the AUP, all those things to the customer, but also to the customer's customer. And so from a contractual point of view, I think it's not only important to do that, but it's also important to have the flexibility to change that, because as was mentioned, particularly when you have an aggregation of services, where it's not just kind of the bare metal IAAS, if you've got additional services, those services may go away over time. And you need to be able to, within the time periods given you by whoever's providing those third-party services to you, also go to everybody else in the stack and say, sorry, you're losing that service. And was mentioned by Suzanne at the beginning, you also need to make sure if that's a critical service for you, that you have the remedy to get off the services. If you have a critical service that's provided by a third party, that third party goes away, now it's not a complete set of services for you. So you need to be able to leave without any penalties, without having to pay the rest of the year's fees, because you were depending on that service and now it's gone away. So as you think about this, it's really important to think through the various scenarios where somebody loses a service, or you've got multiple levels of people. And then there's the question of how responsible is your customer for not only for their own actions, but for the actions of people above them. And so if you take a look, for example, at the rack space agreement, they make you responsible. If you choose to resell, you're not only responsible for your own actions, you're responsible for everybody else in the stack. And what we can, and I've done a number of deals where we're reselling through major customers where they're going to have multiple people in the stack. And another approach to that is say, okay, you agree to pass through these terms. To the extent there's a violation of the terms, we can terminate that, that user if you don't. We'll give you notice you can terminate, or we can, after a certain time, we can terminate directly. And rather than being totally responsible for everything that happens above you, we'll let you, if you pass through these terms, you're just responsible for actions outside of the terms, or if you fail to pass through the terms, then you're responsible for their actions, which would have been a violation of the terms, but you didn't pass them through. So it's a complex contractual construct, and you need to think very carefully, not only about your liabilities down the stack, but potential liability arising up the stack.
Thank you. Rahul, some thoughts that you'd like to add?
Yeah, I mean, I think we've discussed some circumstances where you're really a large player providing an end-to-end service, but increasingly we found that people are creating application services on the cloud, but then not holding themselves out as an end-to-end player. And so you beyond a point, you will not be able to negotiate some of these terms with your cloud service provider. So what you do is you just say, for instance, we'll provide this particular service, but in order to host the data, you enter into a separate contract with whoever the data service, the data provider is. Now, that means that you will still take on the liability for uptime and all of those things, but and where I come from in India, and we'll speak about this in a little more detail later on in the day, content liability is actually very, very serious, and it can be even criminal. And you want to do as much as you can to avoid putting yourself in the position where you are the target for those kinds of actions. If you can shift the liability, as it were, so you can't negotiate better terms in terms of your, more protective terms in terms of your content, just shift that liability and only offer the application service. This may not have been possible earlier, but data today is such a easy to obtain commodity with so many providers that easily integrate with your application services that it is certainly something very viable in today's context.
And I think that the fact that you can offer that as an alternative to a customer, which is to say, I can't make these commitments, and I don't want to be between you and the cloud vendor, whether it be Azure, Amazon, Google, so you go do the deal directly. To me, that also gives you the ability to say, hey, if you were to go host on Amazon, you'd have those terms too. Why should I take on risk that you would have if you did this yourself? So that gives you an alternative to literally avoid the liability, but also a negotiating posture, which I've used. The other, I think Aileen mentioned this too, is there are times where you may decide you need to take on that liability, and as long as it's limited to service level commitment or service level credits, for example, because what a customer says is fine. I understand your position, but I'm paying you, I'm not paying Amazon, right? And if the service goes down, I should have some credit. So taking on some of that risk, giving service levels that you're not necessarily getting, may be a reasonable thing to do as long as your liability is limited.
Yeah, and I agree. I think the point of remedies is a critical issue here, because where you really can get in trouble is if you make commitments that for something other than, something like service credits, if you're actually going to pay damages and you're not covered, and that's
too much.
Yeah, that's problematic.
And
And clients will call you out on that. Your customer sees that you're making excessive commitments, and then they challenge you on where's your back-to-back.
Yeah.
Again, it could be the end of your contract. What we're also seeing is that customers that are in that situation, like Rahul said, is they're coming up and say, listen, why don't you contract with Amazon direct? We're just a startup in Ireland, and getting the customer comfortable that the service or software they're providing is genuinely fully portable outside that environment to other service providers. Or in a worst case scenario, it's reversible, i.e. you could bring it back in-house. So again, some of the smaller companies we would see trying to get customers comfortable around that. And also we see also vendors on a slightly separate point, we see vendors like NCC that provide escrow services. in terms of a lot of, if you're dealing with a smaller cloud provider in Ireland, insolvency is always a concern. What happens if they go out of business? And again, we see people like NCC, third parties who are providing SaaS-assured data extraction verification. They go in there and they check to see, can the data really be extracted, and clearly pay a fee. And they have a second service out now called SaaS-assured, where if the company goes down and goes bankrupt, they will continue to pay the likes of Amazon for a 90-day period to keep the software solution up and running. So we're seeing those types of service offerings out there from third parties, which are
To help take care of this layer cake problem.
And I guess the last issue I would mention is, we're talking really more or less about the public cloud. There's always the option of private or hybrid clouds. And I think, I saw a presentation by somebody from Gartner at an OpenStack Foundation summit in Hong Kong. And what he said I thought was very interesting. He put this chart up and he said, look, we're in a world now that's pretty much primary. You're on-premise or you're outsourcing. People are just beginning to think about cloud. The future is going to be much more complex. You're going to have outsourcing, you're going to have public cloud, you're going to have private cloud or hybrid cloud, private cloud, on-premise, and so there are a range of options here, and I think as we talk about these things, I think it's important to understand that by their nature, public cloud is going to be much less flexible on many of these issues than any of the other options.
And I'll just make one more point before we move on to the next one, and that is that one of the things I've negotiated in agreements is, to the extent that I use Amazon, you get what Amazon gets, go look at the website, you understand what it is. But if I move off of that to something that either I control or it's a private cloud, then I'll agree to more, and I'll agree to that I have to get approval rights if I move off. So drawing this distinction, because it does affect your negotiating posture with the customer. I'm going to move on to the next point. I think this is kind of the most complicated set of issues to address.
I do want to just
yes,
mention
sorry.
one more.
Go ahead.
And it's just because it just happened to me recently with this whole issue of negotiating two separate agreements. As with most situations where you have two separate agreements, you have an issue of trying to prove one or the other. So trying to prove that it's not our fault, that it's the host, and then the host saying, no, it's not our fault. And then you got a customer that's sitting in the middle that's very unhappy with both of you. And who are they most unhappy with? They're most unhappy with the software provider whose services they really need. They really don't care that you chose to go use this hosted environment as your solution as a platform. So be careful, for those of you who are service providers, allowing a customer to say, no, don't worry, I've got my own Amazon agreement. Let's just incorporate that, and you'll be responsible for end-to-end. You'll be the first one out to determine whether or not what the cause and effect is and what the root cause is. And then if you can prove that it's not you, then I'll go to them. And then you have this customer going back and forth. So you really, when you do that, have to, first of all, your technology group has to be able to determine root cause and whether or not it is truly just your software. If you're in a multi-tenant environment, it could be the impact of lots of different things happening. And also, if you are using Amazon and you don't know what their contract says or what rights they have to go in and investigate and then solve for problems, you may have an inability to really solve for the problem, and you may just say to yourself, customer satisfaction, I'm going to go fix this. So when you take on the responsibility of putting the customer in the middle in their own agreement, know that it could result in either additional costs, professional services, or a solution that they will refuse to admit, and they will refuse to even potentially resolve, because there's also issues of ownership of the problem. So I'm
Good
just
point.
letting you know,
Thank
I've
you.
been down
Been
this
there.
road to so many different things.
Well, let's move on to another issue that I identified in my introduction, and that is, as a vendor of cloud services, what kind of patent indemnity are you willing to give? And as a customer, what do you want to ask for? And Mark agreed to address this because there have been some recent developments, again, that make it a little harder or a little easier to negotiate.
Well, I think, ironically, what you find in many agreements is there is no patent indemnity. And I think that's reflective of the fact that many of the initial IaaS services were basically meant for consumers who were not terribly interested in it. But I think you are seeing a bit of a change there, and I think it was interesting. I took a look at the most recent set of agreements, and one stood out in particular, the Google agreement. And Google obviously is playing make-up ball here a little bit, because I think Amazon most recently is 60%, I think, of public cloud or maybe even 70%. So that, and so, as a practical matter, one negotiating tip is maybe you want to go to some of the newer vendors to see if you can get more flexibility there. But the development that was mentioned is a case that came out of the Supreme Court in early June around Limelight. And the Limelight decision went to a core issue, which has been a problem. It's Limelight Networks Inc. versus Akamai. And what had happened was, the question was, what happens if you've got a multi-step process and some of the steps are done by one entity and they encourage other people to do the other steps? In other words, at the worst level, you could say somebody, deviously say, I'm just going to do these two, and then I'm going to have other people, take the additional steps, therefore sidestepping liability. Or I think the more realistic is in a cloud environment where different, different functions are being handled by different people, sometimes by customers, sometimes by the cloud service vendor. It's very easy to see a situation in which all the steps in a patent are not done by the same person, once again, simply because of the way the cloud services are provided. So what had happened in Limelight is, after the dismissal at the district court, the Court of Appeals Federal Circuit said, well, you can have a situation in which a single entity does not take all the steps in the patents, but instead takes some and induces other people to take the rest, and therefore they'd have liability on that basis. Supreme Court reversed and basically said, no, if you go back, the test is that a single entity has to take all the steps, and more importantly, we took a look at the statute, and Congress does know how to write the law in a way which would say inducement for what would otherwise be non-infringing. So that's a very recent development, which actually I think relieves a bit of a burden in this question of, if you're a customer and you're working with a cloud service vendor, that particular theory doesn't look like it's going to hold water in the future. Nonetheless, I think as a cloud service vendor, obviously you'd like to get away with as little as you can, and a number of people have taken that approach to heart. But I think Google, as I said, actually does have a pre-traditional identified, defend, and hold harmless against all liabilities costs, including for Google technology, interesting phrase, used to provide the services excluding any open source software. So one of the questions that comes out of there is, what's Google technology? Is that an attempt, a subtle attempt, I think, to sidestep any liability for third-party technology that's been implemented? Clearly, they've expressly excluded open source, not an unusual exclusion, but the use of the term Google technology, I think, is very interesting, because if they're providing third-party services, maybe in storage or something else, does that mean now that's not Google technology and therefore they're not indemnifying you? And it's also interesting that Google has the typical, repair, replace, or provide non-infringing functionality, but they also say if Google does not believe the foregoing options are commercially reasonable, then Google may suspend or terminate customers' use of the impacted services. So once again, something I think we've seen, basically in many traditional on-premise software licensing now sort of migrating to the cloud. So I think as a practical matter, you're going to have to take a look at the various vendors, because I think some vendors have taken the position, and they apparently feel that they can do this from a business point of view, of not providing any indemnity. Now, like all things, if you bring out a checkbook that has enough zeros on it, you may find that they will take a different approach. But I do think that it's important to take a look at the agreement and understand that from going in, because at least my experience is with lawyers, frequently what happens is you're brought in to negotiate after they've gone through all the cloud service vendors, and they have basically they've made a decision who they're going to go with. So and these sorts of issues rarely get put into the mix when they're making those distinctions. And I think the other piece of this is there's the liability for obviously for infringement of their technology, But the other question, and this came up and was the source of an immense amount of negotiation, what happens if there's a breach of their security and your software that's on there, and I'll describe the situation in a minute, or the data becomes, other people can get access to it. And that is, in the general situation, obviously we all think about that, but one of the deals I negotiated, somebody was putting up a certain type of design software, which I'll be vague about because there's not a lot of vendors in this space. And they were putting up the design software, which was very valuable to them. And then their customers were going to use the design software to develop designs, which were also very, very valuable. And the question was, how much responsibility would the cloud service vendor take for that, for the potential that there was a breach either for the customer's data or the original software data? And what we ended up negotiating was a sort of a tiered approach to liability based on how much revenue the cloud service vendor was getting. But as you think about some of these issues, I think it's important to recognize that at least now, I think we're at a pretty nascent stage that many of Rackspace, for example, does not give an indemnity, but many of these contracts are written for small businesses. And if you can get into the process early enough to put this on the list, so at least you find out if there's flexibility, then I think you're going to be in a better situation. Your clients will be in a better situation. But if you're brought in and says, okay, we're going to do the deal with XYZ, and XYZ knows that, then particularly for these provisions which have high level of risk and where they've already got a policy in place, it may be very difficult to negotiate.
I am going to move us on. Thank you for that.
You're welcome.
And I'm going to move us on to the next question. I'm mindful of the time and mentioning privacy and data protection in the cloud. With Europe being still the most restrictive privacy regime, I'm going to ask John about negotiating those issues in the cloud context.
Right. And I know there was two other sessions earlier on today which are very relevant to this discussion. One was around privacy in the cloud, and the other one was around security in the cloud. Again, I'm not going to go through those sessions, but there were some very useful best practices discussed at those sessions. A couple of best practices, I think, current best practices, I think you should look at if you are doing business with European customers or processing data in Europe or processing data about Europeans. The first thing is you can establish a workable data privacy structure. You have a choice to deal with all the regulators or one. It's up to you. You can have 30 guys going around the laptops processing data in every single European country, controlling data in every European country, or you can centralize it in one jurisdiction, which again is a best practice. The larger e-commerce companies, we typically see them centralizing their data control around one jurisdiction, having the appropriate contracts in place, and making sure their data privacy structure, which is not unlike a tax structure, is based around the jurisdiction. And traditionally, a lot of these structures are based around Ireland. And again, if you do set up your privacy structure in Ireland, you'll generally end up dealing with one regulator. It's Billy Hawkes, who's sitting up there. He's the Irish Data Protection Commissioner. But you will also be subject to, I think audits are going to be systematic. But what I would say is I would certainly recommend it from a cost, from a compliance perspective. Having a single data privacy structure is worthwhile for the e-commerce company. Another best practice to consider, and again, we were chatting about this over lunch, but given that the EU standards are what they are, then cloud computing companies should consider setting those standards as their default on a global basis. It is quite difficult to do business with one set of standards for your European customers and a different set of standards for other jurisdictions. It's also difficult to monitor it, to ensure compliance. So perhaps from a business perspective, it may make sense. And as Billy said in one of the presentations, good privacy can be a competitive differentiator in 2014. So something to think about is on those lines. The other area which we're consulted about a lot are in relation to data transfers. And there were discussions earlier on today about how do you move personal data out of the European Union to the US and also to sub-processors. We noticed recently that Microsoft got an EU regulatory approval for its cloud computing agreement. It was in April 2014. And there's been quite a lot of publicity around that in terms of that the Article 29 Committee approved the Microsoft cloud computing agreement in terms of it will deal, and it's appropriate for dealing with transfers of personal data outside the EU. It also insulates them quite a bit in the event that the safe harbor is for some reason suspended. It also deals with processing and transferring of data outside the European Union generally. So it is something to think about in terms of being a competitive marketing advantage.
Can I ask you to clarify then, you're saying Microsoft's publicly available agreement has been approved? And
Yes,
so for other vendors of cloud services, that is an option, is to seek approval of that agreement. So I think that's one point that you're making, is that
It
right?
is, yes, and actually they got it pre-approved before they rolled it out. So they went and they said, hey, here's what we're proposing to do in terms of our standard contract. Specifically, they would have been looking at the clauses relating to transfer of personal data, and that is now approved, and there was quite a bit of publicity around it. It was mentioned, I think, in the data privacy session. So again, it's an interesting competitive advantage. As of April, they indicated that they were the first and the only company to have this. So again, it's certainly something to look at. It may not be for everybody, but certainly an option to look at. Allied to that also is, again, we would see what cloud computing companies coming in to do business in Europe. We would say to them, educate yourself about what are the mandatory requirements from a privacy perspective, because they're the questions your customers are going to look for. And why don't you think about adjusting your standard terms and conditions to deal with those minimum requirements? Take a lot of negotiation out of the discussions. There's some of the what I would call current best practices. Just want to mention 3 quick snapshots of future issues. One is U.S. search warrants. There's a court case USA against Microsoft in New York at the moment, whereby a search warrant was granted against Microsoft in respect of data which is hosted on a server in Ireland. So that's currently under appeal. I believe Apple, Cisco, AT&T have all filed briefs this week. And that's a case which we'll all be watching very, very closely. The danger for the U.S. companies is if search warrants can be granted against a U.S. company in respect of data that's physically sitting in a foreign jurisdiction, it may affect their competitive advantage as against non-U.S. cloud providers. And again, there are cloud providers out there making noises about we're NSA proof. I wouldn't like to try it out, but they are making those noises. So again, it's something to be aware of. And the other things to watch is the right to be forgotten. Court case recently in Europe, the right to be forgotten in respect of Google, and I'm watching the new EU data protection regulation. They're all best practices for the future.
Thank you. I think the suggestion to tailor your privacy posture and your agreement to the least common denominator, in a sense, which is what you're saying in terms of these issues, which is Europe, is one that companies want to think about. I'm going to keep us moving on so that I hope we have a little time at the end, but I want to make sure that we hit all the issues that we've prepared for. So I'm going to turn it over to Rahul next, who alluded to this before. In the U.S., the DMCA notice and takedown, thanks to some recent cases, is very well established. But the question is, how does this work what are the safe harbors, and how does this work in other jurisdictions? And Rahul had a couple of comments in particular about India, which is a different regime.
Yeah, so I mean, I want to preface my remarks now by saying that cloud computing is alive and well, even though after I say this, you'll think that it's on the verge of imminent death. But one of the biggest concerns that anyone who hosts data has in India is in relation to the notice and takedown type provisions, the fact that the government has access to data, and that the government can pretty much requisition data without going through the kinds of hoops that you probably need to go through in other countries. Vodafone recently published the transparency report, and if you saw the line item relating to India, they specifically say that in India it is illegal to even talk about the number of the number of requests we've received from the government for legal intercept and things like that. So we do have detailed provisions both in our Information Technology Act as well as in the Copyright Act with regard to notice and takedown. It's interesting to note that under the Information Technology Act, it's an extremely broad set of things that are regulated. So there's pornographic content, there's defamatory content, all of which are also have criminal penalties. And we similarly have a specific provision in the Copyright Act with regard to notice and takedown. But the fact of the matter is that at short notice and with relative impunity, Regulators and enforcement agencies can request for information. And if you're a cloud service provider who has to abide by certain international norms, you'll find that it's actually very difficult to negotiate your way out of that situation. One of the things that some of our clients have been exploring is to say that we are a US or a non-Indian company, and so you have no access to the data. You'll have to actually file the writ for that data in the US. And so the challenge with some of those things are, as long as you have a marketing office, or if you've got operations in India that's actually reaching out to customers in India, the Indian regulator is going to put pressure on those customers. When I talk about pressure, I mean literally after a point in time say that the director needs to come to the police office to actually answer these questions in a little more detail. So those are some of the situations that I think is really important to keep in mind as you're dealing with other jurisdictions that are slightly we're on the learning curve, shall I say, and in the recent past, more and more decisions have come out where some of these situations are being dealt with a little more maturely and sensibly.
So what would you say is the recommendation for customers who are contemplating entering into a cloud services agreement with a company in India or a company that hosts its operations in India?
So
Is there anything you can do to protect yourself against these situations in the agreement?
I think actually you're taking the argument that we are at least the data is owned by a non-Indian entity is an argument that will work. It's not like it will not work. What will not work, what you will not be able to avoid is the harassment of actually having to go and explain it. Today, most of my clients are saying we don't even want the harassment, but I say, this is a 1.2 billion individual market, and there's that small bit of pain that you'll need to suffer in order to be able to address that market. Eventually, I think it's quite clear in law that you will not be able to succeed in that action against the Indian entity if that Indian entity is not holding the data.
Mm-hmm. John, comments from the Irish perspective?
Yeah, so I mean, we've had a similar mere conduit defense where as long as you don't have actual knowledge of the unlawful activity, then you have a defense. And if you are made aware of it, then you have to expeditiously remove it. And that's kind of backed up as well by there was a EU Court of Justice case, the Scarlett case, which clarified that there's no requirement to have any general monitoring from ISPs. So again, it's not dissimilar to the US. From the Irish perspective, most of our notice and takedowns, we do them under the US Act because it's usually we're dealing with one of the large e-commerce providers here, and it's typically the US version which we would use for our clients.
I'm going to turn it over to Aileen for the next question, which is we talked about this a little bit when we talked about the layer caking of services. If you're providing a service to a customer that is then in turn providing services to end users, what are the terms that you need to flow down, or do you even need to be a party to the agreement with the end users? How do you go about thinking about how you're protected vis-a-vis the ultimate end user?
We have a tendency of erring on the more conservative side and like to get into end user agreements with our providers when we were providing just standard licensing under the standard licensing model. Now that we are hosting, we have our terms of service and we don't enter into direct agreements with the end users. It would be just an impossible thing to try to get involved with the actual end user and what they want to do. So basically, if almost every single large hosting service has some type of term and condition that they want to have you flow down to the end users, whether it's a notice provision or a restriction on use, or, for instance, the no benchmarking, no penetration testing, those types of things we just automatically put into the contract, and we basically treat it like we did with the open source. It's non-negotiable. This is something that I can't change. I can't go back and negotiate, and I don't even try. We have had several large customers, especially in the financial world, come back and say, go check again. And what they're trying to tell us is that's not what our contract says. So that's the other problem that you have to worry about is oftentimes you'll be saying, well, the customer's giving us these and saying, you know, there's nothing you can do, we're not going to renegotiate them. And then you do find through the back door that, you know, these were not included or they were negotiated differently or they're being handled differently there. And oftentimes we will go back to the customer and say, you know, we have this large customer who's telling us that they might be handling things differently. Is there some other provision you want to flow through for them? And suddenly we'll get a one-off that says, oh, but by the way, they're allowed to do penetration testing, or they're allowed to obscure notices because of the way in which they're going to handle things, or, you know, so forth and so on. But for the most part, we actually include terms and conditions in our agreements that basically says an end user will not hold our customer, our vendors liable for certain things. So we actually will include in the agreement, bury in the fine print. No, but include in the limitation of liability clause a statement that says, you know, they're not liable, neither are we for certain things. And so, for instance, they're not liable for any open source that's included in their hosting environment, just like we're not liable for it as well. So we'll flow those through, but it's pretty standard. I mean,
so you're flowing down terms to protect you, and you're also flowing down terms to protect your vendor.
Exactly.
Yeah.
And you know, frankly, I even though I know everybody's kind of a little bit concerned about hosting, it's basically we haven't really had to treat things very differently. Our indemnity is still pretty rock solid with the standard indemnities, whether we carve it out of the limitation of liability or not. You know, pretty standard. That same discussion goes back and forth. The customer says they want it carved out. We say no way. Same type of indemnities, even though now we are starting to look at whether or not we will indemnify, not just for patent infringement, but for also for data privacy, data protection issues.
Those are the main differentiator between
We're starting to actually
licensing.
provide those types of indemnities, and we're seeing that our counterparts in the service provider world are providing indemnities for breach of data protection, data privacy, based on our own plans, not on our customers' plans.
So we're about out of time, so I'm just going to try to squeeze in two quick comments before we go. The first is Mark. One of the things that we had talked about is what happens if the cloud services vendor that you're dealing with actually needs to go procure excess capacity or add-on services from another party. How do you protect yourself from knowing A, where your data is stored, and B, who's providing the services?
Well, fundamentally, it's a diligence issue. You know, once again, to the extent you're dealing with cloud service vendors, you're not going to change their whole way of doing business. But what you need to understand is how they are doing business and need to understand how that's going to affect you. Now, you may, in certain circumstances, negotiate something where the fallover capacity goes onto their own servers and not onto some unknown third party behind them. But really, it's a matter of asking them. And I think, you know, when you're talking with a Google, you're talking with a Amazon, this is obviously less of an issue. But I think if you're using a smaller cloud service vendor, you really need to do your due diligence to understand how much of the system is theirs and how much of it is, you know, provided by third parties. Because, you know, in addition to the question of can you trust them, you're not going to have contractual privity with them. But even more importantly, if they go out of business, you know, there's a lot more risk if fundamental parts of the functionality you're interested in are being provided by third parties.
Thank you. And the last issue I'm going to let John deal with is what are some unique tax issues in the cloud in your transactions?
Well, I was originally going to talk about tax obligations and tax opportunities, but because I'm in Silicon Valley, we'll just focus on the opportunities. Two issues to be aware of. One is next year in Europe, they're changing the way VAT is accounted for. If you are selling business to consumers, if you're dealing with European consumers, even if you're dealing with them remotely from the US, you are liable today to account for VAT, but you're going to be liable to account for it in a different way. So today, if I buy an electronic service in Europe, typically it'll be from one of your subsidiaries in Luxembourg, and I'll pay 15% VAT. That's how it works today. Next year, the way it's going to work is that that company, whether it's in Luxembourg or wherever, is going to have to account for VAT at the local rate. So the VAT in Ireland is 23%. So from next year, you will have to charge me 23% in Ireland, notwithstanding that you're dealing with your Luxembourg subsidiary, which is charging 15%. It's going to have, you need to check your pricing clause to see, can you do an adjustment? You also need to look at your structures to see, do you want to keep the Luxembourg entities? Because pretty much all the electronically delivered services come out of Luxembourg because they have a 15% VAT rate. That competitive advantage is going to go for Luxembourg in 2015. You will have to account for the local VAT rate. And the question is whether you put your price up for the Irish customers, or do you have a flat rate and absorb that increase in VAT? That's a big issue, business to consumer companies. The second issue is if you've got intellectual property, strong intellectual property, as you would do being in the cloud providers, golden rule is do your international tax plan as early as possible. The single biggest, I won't say mistake, lack of opportunity we see is when e-commerce companies come to us very late in the cycle. So most of the times we're seeing e-commerce companies and cloud companies coming to us after a Series B round of funding to set up their international tax structure. Generally, if you set up an efficient international tax structure, your effective tax rate on the structure should be 5% or less for your international income. And if you don't, it'll be 35%.
Terrific. I actually lied. There's one more. Rahul will have the final comment on termination and what to be aware of when negotiating termination provisions in cloud services agreements.
So, and I'll keep it brief. I think when we are terminating, essentially you're taking your whatever you've hosted on the cloud service provider and you're moving to someone else. And one of the big concerns really is your data going to be in a usable format when you've taken it out? So it's interoperability. It is, are you in a position to actually, you've hosted it on this, it's worked fine in the cloud service environment. You need to find a new vendor, and will it work in exactly the same way? I think the nuts and bolts of it will, but all the other layers that you've gotten so used to, the metadata that's organized your service in a particular way is all gone away. And very often, I mean, today we're dealing with clients who haven't done this in advance, who are now having to deal with the problems of their past. They just pick that up. It becomes a data dump. This is, pre-2014. There's a lot of this data that's there. I think we'll need to struggle to get it out, but at least it's there. And I will start with a clean slate from 2014 onwards. If we can work those things up front, I think now a lot of cloud service providers actually guarantee that it is interoperable, that you will be able to take your data away and use it. I think looking into actually testing it every now and then will be useful, because you may be able to take it away, but it may not be in a format that's actually usable, particularly when you've got 3 or 4 years worth of data.
Very good point. Well, thank you for attention. Sorry we ran over a little late. I think we can all stick around if there are further questions.